Ms. Kruger.
Judge. Good morning. I am the Registrar Clerk for this hearing. Justice Madlanka and Justices of the Constitutional Court, all counsel are online. I call the matter of Andrew Tuee Baloyi NO and others, and Pornstars CC and another for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Please, I appear for the applicants. Sam Cohen.
Thank you, Mr. Cohen.
As it pleases, I appear for the respondent.
Thank you, Mr. Dobie. Yes, Cohen.
Thank you, Justice Madlanga. The appellants have two obstacles to overcome in this appeal. The failure to overcome any one of the two obstacles is fatal to the appeal on the part of the applicant. The two issues are as follows. Firstly, whether the phrase judgment debtor, as it appears in Rule 46A, can be said to apply only to a natural person, or does it also apply to a trust or a company? If the court is against the appellants on that and finds that natural person and judgment debtor are the same, then the appellants will be non-suited in their argument. The second issue is, even if the court finds that judgment debtor extends beyond a natural person and does apply to a trust, whether or not the court is inclined to vary the settlement order, which was made on the 17th of April 2018 by the judge president in the Polokwane court, on the basis that the order, properly interpreted, makes provision for the property to be sold in execution in the event of the trust defaulting on its installments, and whether the Constitutional Court is prepared to vary the order so as to make the provisions of Rule 46A applicable. My submissions on the applicability of judgment debtor to a trust are set out in the heads of argument. Very briefly, if I may just summarize, in terms of Rule 46A, the rule provides that this rule applies whenever an execution creditor seeks to execute against the residential immovable property of a judgment debtor. There are two jurisdictional facts. The first is it has to be residential immovable property, and secondly, that must belong to a judgment debtor. The purpose of Rule 46A is judicial oversight. And in exercising judicial oversight, a court takes into account who lives in the property, whether they're children, what the arrears are, how long the arrears have been owing, in setting a reserve price, what the value of the property should be for the purposes of a reserve price. In my respectful submission to the court, if the property is registered in the name of a trust, that inquiry can still be undertaken by the court in exercising judicial oversight. It won't make a difference if the property is in the name of a trust. On the facts of this case, the court has all the information before it as to who lives there, an estimation of what the property is worth at market value, what the reserve price is. There are children who occupy this property. And the fact that the property is the name of a trust and that the Baloyi is elected to place the residential property in the name of a trust is not unlawful. It's not an unlawful act to put property in the name of a trust, albeit that it's a residential property. On the second issue, the variation of the court order, this court can and does have the power to vary the order, the consent order, notwithstanding that it was made by consent. And in the judgment of Kevin John Eek and Charles Henry Parsons, a judgment of this court in 2015, Justice Madlanga, what was said on behalf of the court was that the power conferred on the High Court, Superior Court of Appeal, and this court in Section 173 is not an unbounded additional instrument to limit or deny vested or entrenched rights. The power in Section 173 vests in the judiciary the authority to uphold, to protect, and to fulfill the judicial function of administering justice in a regular, orderly, and effective manner. Said otherwise, it is the authority to prevent any possible abuse of process and to allow a court to act effectively within its jurisdiction. And this court went on to say at paragraph 30 that this is equally true of court orders following on settlement agreements, of course, with a slant that is specific to orders of this nature. And then what was said at paragraph 30 is that the court order in this case records an agreement of settlement, and basic principles of the interpretation of contracts need therefore be applied to ascertain the meaning of the agreement. And then the court goes on to talk about how the intention of the parties is to be ascertained. On the interpretation of the settlement order, the only interpretation it's capable of is what was intended by the parties was on default, the property was going to be sold in execution. And the question, and my respectful submission, is that not to make Rule 46A applicable would be against public policy, because there is, with respect, no reason why the trust should not have the benefit of judicial oversight in the sale of the property. It's beneficial both to the trust and to the respondent, in that if regard is had to the conditions of sale, which are no longer extant, there was a reserve price there of 1,000 Rand. At the moment, there's probably about 1.3 million rand owing by the appellants to the respondent. The primary benefit of applying Rule 46A would be the setting of a reserve price by the court, which on the facts which are before the court would be more than the 1.3 million rand, which is owing at the moment. Secondly, this court in Eek also considered whether the fact that, notwithstanding the parties have settled their dispute, they come back to court for further relief. An example given was, for example, to ascertain what the installments would be that are owing under the agreement. That doesn't apply in this case, because there's sufficient before this court to judicially supervise the sale of this property if the court is so inclined. If the court's not so inclined, the matter can be remitted back to the Polokwane court only on the issue of setting a reserve price. So Justice Madlanga and the justices of the Constitutional Court, those are my two submissions, as the court pleases.
Thank you very much, Mr. Cohen. Colleagues, any questions?
Mr. Cohen, I have a difficulty with jurisdiction in this matter. Why do you say this court has jurisdiction?
I'm sorry, Justice Majid, I'm not understanding.
Yeah, on what basis do we have jurisdiction to hear the matter? What is the constitutional issue, and what is the point of law of general public importance here?
The point of law is that the function of Rule 46A is to provide judicial oversight in relation to property rights in terms of Section 26. This appellant, because it's a trust, has been excluded from Rule 46A by virtue of the full bench decision in Falsha in 2011, which, although that decision interpreted Rule 46 and Rule 46A came into operation in December 2017, it does not affect the interpretation which His Lordship Mr. Justice Bertelsmann placed on judgment debtor, because judgment debtor appears both in Rule 46 and it appears in Rule 46A. So a natural person,
when this application was launched, was Rule 46A already in operation?
no. But Justice Majid, when the order was made, when the settlement order was made, it was on the 17th of May 2018, and Rule 46A came into operation in December of 2017. So Rule 46A preceded the settlement, the order.
Yeah.
If I can refer to it as the consent order.
Yes. Well, we determine jurisdiction on this point of general public importance. The law is clear here in this court that the jurisprudence shows us that that must be determined on the pleadings. Was this ever pleaded before you came to this court?
No.
I'd like you to show me, because I never seen
wasn't.
it. It wasn't pleaded.
It wasn't, Justice Majid.
Because this application was brought on certain grounds. The rescission application, first, alleged lack of proper service, the question of the amount that was claimed, and also you raised a constitutional issue, the fact that there were children residing in the primary residence, and then the Conventional Penalties Act. So if we decide this particular question as a point of general public importance, we would do so as a court of first and last instance, not so. No other court has considered this before.
No.
I mean, the High Court hasn't done so, and the SCA hasn't done so. That's what I mean.
There is one High Court decision that I found where this was considered.
No, you're misunderstanding me. I'm saying that in this case, neither the High Court nor the SCA has been faced with this particular issue. Do you concede
Justice Majid?
And this court doesn't, as a rule, sit as a court of first and last instance. On what basis do you say there are exceptional circumstances for us to do so in this case?
Justice Majid, what happened was that after the rescission application, the matter was settled. This appeal arises from the dismissal of an application brought subsequent to the consent order, where relief was claimed that the property be sold with judicial oversight in terms of Rule 46A, that the writ of execution be set aside and that the property be sold. There's a counter application brought by the respondent in that matter to the effect that if relief is granted, then the property be sold with judicial oversight. And what was before the court already in Polokwane were all the factors which the court would need in order to exercise judicial oversight. So what this court is considering as a court of first instance is the question of whether or not Rule 46A applies to a non-natural person. And that was raised. In the answering affidavit, the respondent contended that because the property is owned by a trust, Rule 46A can't apply.
Yeah, I'm not sure it answers the question, but let me go to the second question I have, and that's a question of judicial oversight. I'd like to take you to the papers, Mr. Cohen, specifically the papers in the SCA, the answering affidavit of the respondent at volume 4, page 234. If you could just go there, please. Volume 4, page 234. And I'm referring you to paragraphs 8 and 9 there. Actually, we should start at 233, just on the preceding page, paragraph 8. The first respondent, deponent, Ms. Kemp, sets out what was deposed to in the affidavit in the what she calls the enforcement application. She starts there and she says that she claims that the trust was the owner of the property and so on, but I'm more interested to continue in 8.4. She says the applicant's attention was drawn to the provisions of section 26(1) of the Constitution. At 8.5, she says there were opportunities to make repayment arrangements, failed to do so. She talks about the trust movable assets at 8.6, and this is the one that interests me, Mr. Cohen. 8.7. I also invited the applicants to place facts before the court should they believe that the property should not be declared executable. And then 9, as the applicants did not oppose the enforcement application, the order was granted by the court after having considered all the facts set out in the affidavit, which order included an order declaring the property executable. There was accordingly judicial oversight. That's the averment that she makes. And then I want to take you to your reply at page 23, at volume 5, page 246. Bearing in mind what was averred there and what you then answered at page 246 in volume 5. You deal with paragraphs 8 and 9 there. You say at paragraph 8.1, there is an error in this paragraph. And then you deal with paragraph 13.3 to 14. These are averments in paragraphs 13.3 and 13.4 of the papers. You say, although your lordship, Mokotla made the consent order, his lordship, which should actually be his ladyship, her ladyship did not exercise judicial oversight in regard to declaring the property specially executable. The applicants have never contended for a mistake. The rest of the averments are left unanswered, not so?
It is so, Justice Majid.
Where does that leave the applicants on this question of judicial oversight?
It's an admission. The rule
Yes.
provides if it's not denied, it becomes an admission.
Yes. Anyway, thank you. That's all I wanted to ask you. Thank you. Thank you, Justice Matlanga.
Thank you, Justice Majid.
Thank you, my brother. Thank you, Mr. Cohen.
If I may, Justice Matlanga,
Oh,
please.
yes.
With your leave.
Yes, Justice.
Mr. Cohen, the applicants have not sought to rescind or to challenge in any way the order of 17 April. Instead, they seek a variation of that order and to set aside the writ of execution.
Yes.
Now, where that is the applicant's case, what relevance does the question whether Rule 46A applies in respect of residential property owned by legal persons have in this matter?
Justice Tehran, the consent order allows the property to be sold in execution on default of an installment not being paid. So notionally, the property can be sold at a reserve price of R1 or R1,000. In fact, the conditions of sale did make provision. If Rule 46A is applicable, then the court would set a reserve price. And on the evidence, the reserve price may well be R1 million or R1.5 million.
Let me rephrase my question, Mr. Cohen. Why have the applicants not sought to rescind or challenge the order of 17 April?
They limited the challenge to a variation of the order so as to make Rule 46A applicable. That's the high water mark of what the applicants sought to do. They never sought to rescind it.
Why not? Wouldn't that have been the best option for the applicants?
My lady, in retrospect, it probably would have been. Also, what would have been an option for the applicants would have been to seek a declarator that the property be sold in terms of Rule 46A.
Yes, and that would have entailed them bringing a separate application with that order in mind.
My lady, I apologize. My junior has just drawn to my attention that my camera wasn't on. It wasn't intentional. I wasn't aware of it. I apologize. My lady, may I ask you again to repeat the question? I'm sorry, I was distracted.
Yes, yes. I think my question was, wouldn't it have been a better option for the applicants to have sought to rescind that order of 17 April?
It would have been with respect, my lady, in retrospect.
And then you responded by saying they could also have sought a declarator. That might also have been a better option.
Yes.
To seek a declarator that Rule 46A would be applicable, instead of seeking to rescind and or seek to vary a consent order.
Yes.
If I can
It
refer
would have,
you
with respect, my lady,
to volume 4 at page 141, Mr. Cohen.
I have it, my lady.
That was the applicant's application for leave to appeal in the High Court. And particularly at paragraphs 15 and 16, where I quote, or I read from that, the learned judge correctly found that the right to housing is recognized as a fundamental right by section 26(3) of the Constitution, and that the property which is registered in the name of the trust is being used as a dwelling for the trustees and the children who are natural persons. The learned judge correctly referred to the decision of Nedbank versus the trustees for the time being of the Mtunzi Mdwaba Family Trust and others, where the learned judge Hamaputla AJ correctly held the trustees in their official capacity do not have to be judgment debtors for Rule 46A to be applicable.
Yes.
It seems that at that stage already, the applicants accepted the issue of the applicability of Rule 46A, and that was correctly decided by the High Court.
My lady, I want to clarify that the learned judge, Her Ladyship Acting Justice Madava, who dismissed the application, did apply the decision of Nedbank and the trustees for the time being of the Mtunza Mdwaba Family Trust, but non-suited the applicant on varying the court order so as to make Rule 46A applicable. It is, with respect, my lady, a non sequitur that to find that the Nedbank decision applies, that the trust does enjoy judicial oversight in terms of Rule 46A, but then to dismiss the application on the basis that no rescission or variation was established. That's exactly what we sought, my lady, was that Rule 46A should apply.
Please correct me. I'm sorry to interrupt you, Mr. Cohen, but correct me if I'm wrong. I had read paragraphs 15 and 16 to mean that the applicants accepted the manner in which that aspect was decided by the High Court. And therefore, Rule 46A was not relevant to the High Court's dismissal of the application. So I'm a bit confused as to why it's being raised now, why the applicability of Rule 46A is being raised at this stage, and whether it's relevant to this matter.
I understand what your ladyship is putting. The context in which this was meant, my lady, was that the court, having found in terms of this decision that Rule 46A was applicable, should then have varied the order to make Rule 46A applicable. This decision, my lady, may I respectfully say, is the only decision I'm aware of where there has been a finding that Rule 46A does apply to a trust.
So please correct me again if I have misunderstood you, Mr. Cohen. You accept then that the High Court found that Rule 46A was applicable?
Yes.
So I'm still not clear about what we're doing now. If that was already found by the High Court, I don't understand your argument when you say this court must now make a finding that Rule 46A is applicable.
My lady, the context of my submission is that it's conjunctive, in that the High Court, on the appellant's version, having correctly found that Rule 46A is applicable to a trust, should have then varied the order and allowed judicial oversight as a condition precedent to the property being sold.
Now, if that's the applicant's case, where do I find that in the applicant's submissions? That because the High Court found that Rule 46A was applicable, it should then have varied the order.
You won't find it, my lady. The submissions in the submissions are, the core submissions are whether or not Rule 46A applies to a trust or not.
But if the High Court already decided that issue, why should we decide it again? If the High Court decided it and the applicants accepted it, why should we decide it again?
Because, my lady, it's a lone decision in the wilderness. There's a full bench decision. There are two full bench decisions in Gauteng, which have already found that natural persons, that Rule 46A is only applicable to, or judgment debtors means only a natural person. This judgment, which your ladyship referred to, was strongly criticized by another single judge in the Johannesburg division, in the Fraser decision, which I referred to, in Vestec and Fraser. Every judgment is against the Nedbank decision.
Now, Mr. Cohen, if I understood your earlier submission, you said because the High Court found that Rule 46A was applicable, it should then have varied the order. Why would the applicant be entitled to a variation? Simply because Rule 46A applies. And I think this brings me back to my earlier question, variation rather than rescission.
My lady, I understand the difference between a rescission and a variation is that in the former instance, it's necessary to rescind the entire judgment. Whereas with a variation, it's not necessary to rescind the entire judgment, but just to vary. In this particular instance, we asked for the order to include a phrase that the property is to be sold under 46A. That was the variation that we sought. We should have, my lady, in retrospect, sought a declarator.
Now, in the absence of a challenge setting aside the order of 17 April, on what basis can the applicants be entitled to an order setting aside the writ of execution?
On this basis, my lady, that if the court finds that Rule 46A should be applicable to the order, if my lady has regard to the consent order that was made, which, if if I may just find where it appears, I had a note of it. My lady, if you'll just bear with me. It's on page, it's volume 3 at
You're
page
looking for the
62.
consent order of 18 April.
Yes,
That's in volume 1, page 23, I think.
my lady, may I just ask my junior to go next door? They're busy drilling something. They're doing a renovation. I'm sorry.
Yes. Yes, you may.
Thank you. Just go next door. Tell them to stop drilling. It's next door.
17 April or 18 April?
Please continue, Mr. Cohen.
I'm sorry, my lady. The settlement order. I have it at AB5 in volume 3. Page 62. If I may ask the court to go there, it's volume 3, page 62, annexure AB5. And at page 64, what the order provides is that at 1.3, that in the event of any installment not being paid on due date, the full balance of the repayable amount then shall become immediately due, owing, and payable. And then 1.3.2, this property shall become specially executable. And what should have been asked for in the form of declaratory relief is that in the property becoming specially executable, there's judicial oversight under Rule 46A. Because at that time, the new rule was operative. It had come into operation in December of 2017. And not to have included that in the order is inimical to the interests of both the applicant and the respondent.
Now, Mr. Cohen, the applicants have not put up any evidence to show that the order of 17 April 2018 was granted as a result of fraud or an error common to the parties. So they simply, if I'm correct, they simply claim variation on the basis of the applicability of 46A. Is that right?
Yes, it is, my lady.
Like Justice Majid, I also have some concerns about jurisdiction. If I heard you correctly in the submissions you made during your protected time, your submission was that if Rule 46A is not made applicable to the agreement and the consent order, it would be against public policy. But I don't understand that argument. Firstly, if the High Court has already found that Rule 46A was applicable, and secondly, would it not be a constitutional issue if the applicants had to say instead that the agreement between the parties, as reflected in the consent order, is against public policy? Wouldn't that then be a constitutional issue?
It would, my lady.
I know I've put two questions there, and you may wish to separate and just...
My lady, I understand perfectly what your ladyship has put to me, and I did consider that. And it's if I may say with very great respect, what your ladyship is putting to me is again perfectly consistent with what this court said in Eek and Parsons. One has a look to see at the underlying settlement agreement which gives rise to the court order. The only submission I can make, my lady, is that in the founding affidavit which served in the Polokwane court, the allegation was made that it's against public policy without expanding or articulating why it was.
Can you take me to that, please, Mr. Cohen? Take the court to that.
I just need to find the founding affidavit, my lady. It's in volume 3.
I think it starts at page 13 of volume 3. Is that it?
Yes, my lady. I just want to find the part B. Sorry, my lady. My lady, my junior has pointed out that it's at page 10, paragraph, it starts at paragraph 16. My lady, at paragraph 18, it is pertinently stated without reasons being given. As I refer further to clause 1.4.3 of the court orders against public policy, by authorizing the registrar of court to issue warrant of execution in respect of property, Rule 46A places a limit and directs the process to be followed. That's the high water mark, my lady. I
think yeah, my question was more that in order for it should have been pleaded, I think, that the agreement concluded between the parties is against public policy.
It should have, my lady. The attack should have been on the underlying agreement, which resulted in the order. And that, my lady, would have made a significant difference to the outcome of this application. But my lady, having said that, if this court finds that clause 1.4.3 of the order, which allows the immovable property which is residential to be specially executable without judicial oversight, and the court finds that that is against public policy, this court, my lady, is at large to grant the relief to vary the order or to make it a condition precedent. And the fact, my lady, that it may result in having to go back to the Polokwane court is not a bar to the court doing that.
Isn't the difficulty that the applicants face, Mr. Cohen, and as pointed out by Justice Majid, even if we were to find that Rule 46A is applicable, the applicants have put up no evidence to show that the property should not have been declared executable. The applicants have not said they will be left homeless if the property is sold. They have not said they will be without access to alternative accommodation. I know this is that could be referred to the High Court, but why haven't the applicants taken the courts, all the courts who have dealt with this matter, in their confidence?
My lady, some facts were put up. Firstly, may I say that I concede what your ladyship is saying, but some facts were put up by the applicant regarding the value of the property. The concern of the applicants, the reason why the applicants seek the protection under Rule 46A is the reserve price. because this property was used as security for a loan. It wasn't used to purchase the property. In order to pay the indebtedness to pawn stars, there's a concession that the property has to be sold. But the applicants would like the property to be sold at a reserve price in order to avoid abuse. Because notionally, this property could be sold for 1,000 rand. I'm not saying, my lady, that that's the likely outcome, but the conditions of sale do stipulate a reserve price of 1,000 rand. Both parties have placed evidence, or did place evidence, in Polokwane as to market value and for sale, and they're not that far apart.
Thank you, Mr. Cohen. Thank you, Justice Madlanga.
Thank you, Justice Tuee.
Justice Madlanga, may I just ask the counsel just one or two questions? Mr. Cohen, when the original default judgment was granted in April 2017,
Yes.
the new Rule 46A had not come into force.
Yes, yes, Justice.
And in the default judgment, an order of special executability was granted.
Yes.
And the notice of motion on which that order was granted contained the order, contained the Section 26 notice, which the Saunderson case required and which this court endorsed in Gondwana.
Yes, Justice.
And the founding affidavit in the default judgment application contained paragraphs which again referred to Section 27 and invited the current applicants to put up circumstances, if they said so, why it would be unjust for the property to be executed against.
Yes.
What happened a year later in April 2018, the settlement order that was made not on an application brought by the creditor, but on a rescission application brought by your clients.
Yes.
Rule 46A came into force in December 2017. And in its formulation, it says everything that a creditor who is seeking an order of execution against immovable property, what that creditor must do in its application. It must set out certain facts and so forth. Now, in the circumstances giving rise to the consent order in April 2018, that wasn't an order granted on the application of the creditor. It was an order granted in settlement of an application brought by the debtors for rescission.
Yes.
So on what basis is Rule 46A applicable at all? Because 46A, it appears to me, to be solely concerned with regulating the process which a creditor must follow if it is seeking an order of a special execution. Now, in April 2018, before the settlement, this creditor already had a valid order for special execution granted under the old procedure.
Yes.
Your clients brought an application and then agreed, fully legal advised, to a settlement.
Yes.
Now, where does Rule 46A enter the picture?
Only in this respect, Justice Rogers, and that's this. The rule became operative on the 22nd of December 2017. That preceded the consent order.
Now, I understand that, but Rule 46A from December 2017 onwards regulated what creditors must do if they are seeking an order of special execution. But at no time after December 2017 did this creditor institute any proceedings to seek such an order. It already had such an order. What followed in April 2018 was an order settling an application which your clients as the debtors brought.
Yes. So Justice Rogers, my submission on that is the order prospectively envisages the property being sold in execution without judicial supervision on the happening of a certain event, namely the non-payment of an installment. In the event of that happening, which may never have happened, the creditor then has the right to execute in terms of the consent order. So the creditor prospectively, after the order is made, might execute on the property. And
Yes,
if the creditor,
sorry,
I'm
carry on.
I'm sorry, Justice Rogers.
No, you weren't finished. I was rude. Carry on.
So the order is prospective as to events which may or may not occur in the future. In the event of a default, the creditor has the right to execute because the property has already been declared specially executable. The debtor defaults, it's now a creditor's application to sell the property in execution. Rule 46A is now operative, or it was operative at the time of the consent order. That was the rationale for asking that the order be varied to afford judicial oversight in the execution of that property, which would have been a creditor's application to execute.
Well,
that was the thinking.
But wasn't it already an order granted in April 2018 in settlement of the application which your clients brought? That order of special executability was made then?
Yes.
On your client's application?
Yes. And it was made at a time that Rule 46A was operative. So the order, not the order, but as Justice Theron, with very great respect, correctly pointed out, this attack should have been on the settlement agreement, not on the actual order. So the settlement agreement should have contained a provision that there would have been judicial oversight under Rule 46A, because Rule 46A was extant at the time that the consent order was made.
Yes, but if you were attacking the underlying agreement, you couldn't cherry pick. You couldn't say, I'm happy with everything in the agreement except the order of special execution, because the creditor may have said, well, then I would not have agreed to rescission. I would have stood by the order I already had. You can't take bits and pieces of an agreement.
You can't, Justice Rogers.
Can I just ask this? Why do you say that the order of April 2018 didn't comply with the requirement for judicial oversight? Is it merely the fact that the condition triggering the creditor's right actually to execute against the property was something which might only happen in the future?
Yes.
Now, isn't that inherent in every execution order? When a perfectly ordinary execution order is granted under the new procedure, there's nothing that requires the creditor to execute against the property immediately. The creditor may reach interim terms with the debtor. The creditor may only execute against the property in 2 or 3 years' time. There's no requirement on each occasion to go back to the court.
There isn't. But
so if I can then just finish the implications of that. It's implicit in every execution order that it may not be acted upon immediately because the order is good for 30 years and the creditor will execute against the immovable property if and when it wishes to, which it may never do. So the mere fact that in this case, the court granted, let us call it a conditional, an execution order subject to a condition, which might result in the execution only being levied in 6 months or 12 months' time. Why does that deprive the April 2018 order of the requisite element of judicial oversight?
Because Justice Rogers, on a fair interpretation of the order, it provides that the property is declared specially executable. Now, if Rule 46A applied, and just by way of an example, a prototypical example would be the setting of a reserve price. When the court has regard to those conditions of sale, which had already been prepared and which were extant, because the debtor had defaulted, there's a reserve price of R1,000. That couldn't have happened if Rule 46A was operative.
Well, of course, the court doesn't have to set a reserve price. Now, what if the judge had read the papers in April 2018, saw what the parties then settled at and said they are both represented by attorneys and counsel. They have agreed to this. I am content, from what I know of this case, to endorse this order. It doesn't have to include a reserve price. And your clients, legally advised, didn't insist on it at the time.
That is so, Justice Rogers. I have to concede that, and I can't take that any further. Except this, that in the application in front of the single judge in Baloyi, there was a counter application brought by the creditor that in the event of the court finding that the property should be declared specially executable, the creditor set out a reserve price for sale. It put information before the court for the setting of a reserve price. So had the counterclaim been granted, in Polokwane, the property, assuming it was going to be sold, would have been sold. It would have been sold at a reserve price.
Then just on the question of the residential property of a judgment debtor and the trust point in the Fulcher case, can I ask, would your submission be the same if the judgment debtor was, say, a landlord, which had just let the property to a tenant? So the property is occupied by a natural person who is a tenant from a landlord, and a judgment is granted against the landlord. Do you say that because the property is occupied by a tenant, that is the residential property of a judgment debtor?
No, I don't make that submission.
So the mere fact that by some arrangement with the judgment debtor, natural people are in occupation of the property doesn't trigger the operation of Rule 46A?
No, Justice Rogers.
So what is the essential difference between that situation and the case of a company or a trust which happens to be related to the natural persons who occupy? Because it does seem to me to be clear that trustees in their nominal capacity as trustees, as fiduciaries, can't occupy. They might give themselves the right to beneficially occupy in their personal capacities, but that then is some or other arrangement between the trustees and a natural person. Why does the mere connection suddenly convert that to a residential property of the judgment debtor?
Justice Rogers, I concede and understand what your lordship, what you have put to me. But on the facts of this, if we take the example of this case, here we have, as a fact-bound inquiry, that the Baloyis and their children are staying in this property. It's a residential property, albeit that they put that in the name of the trust. Now, the court can make that inquiry. There has to be cases of abuse where a party puts a residential property in the name of a trust and goes and rents it out. And what the court is faced with there are not the owners and their children, but tenants. But that is an inquiry that the court can make, and the court would make in every instance.
Whenever a natural person occupies the property by some arrangement with the owner, the court can inquire into the natural person's circumstances. But you see, I think part of this argument seems to presuppose that the only time the court will ever be involved is when the property is declared specially executable. But everything that has been built into the execution process is to safeguard the case where the judgment debtor is the owner of the property and stands to lose it. But if that doesn't apply, so that judicial oversight is not required at the execution stage, at the eviction stage, when you try to get the natural people out, that is when PI and all of those circumstances will be come to the fore. So it is not as if the absence of judicial oversight in the case of property owned by a trust means that the courts will never be involved in deciding whether people should be evicted. It only means that they will not be involved in the question whether the judgment debtor's property should be declared specially executable. Do you accept that that is broadly correct?
I do.
Yes.
I do, and I did consider that, Justice Rogers.
Yes, thank you, Justice Madlanga.
Thank you, Justice Rogers.
If I may, Justice Madlanga, just a follow up, please, with your leave. Mr. Cohen, in the exchange that you had with my brother, Justice Rogers, reference was made to the counter application in the Polokwane High Court. And in that counter application, you made a submission that information regarding the reserve price was put before the court in that application. That application was refused.
Yes,
There is no appeal against the refusal of that application.
there isn't. There is no appeal.
And that is the application that dealt with the reserve price. And if I understand your argument today before us, that is essentially the relief that the applicant is seeking.
There is other. My lady,
Yes, I'm with you, Mr. Cohen.
I'm sorry, I just lost connectivity just for a moment. My lady, there is a supplementary affidavit that was put up by the applicants as to the value of the property.
Yes, my concern goes more to the relief relating to the reserve price. If that was the relief that the applicant was seeking, perhaps the applicant should have pursued an application for leave to appeal against the counter application that was refused.
My lady, the counter application is the respondent's application. That was dismissed. The respondent isn't seeking leave against the dismissal of its own application.
Yes. Oh, I had misunderstood. I thought that was an application by the applicant.
No, my lady.
Relating to relief on, then I have no questions. Thank you.
Thank you, my lady.
Thank you, Justice Madlanga. Thank you, Mr. Cohen.
Thank you, my sister. Thank you, Mr. Cohen. Or do you have any?
Thank you, Justice.
Thank you very much, Mr. Cohen. Mr. Dobie?
As the court pleases. Perhaps to start off, the premise of the application is, of course, that there was no judicial oversight, but the essence of it is not that. What in fact occurred is there was judicial oversight. The sole concern which the applicants are raising is in fact that no reserve price has been set. But that's not a prerequisite for judicial oversight, and nor is it a prerequisite in relation to Rule 46 capital A. It's one of the aspects that may be considered. Having said that, perhaps learned justices, in fact, dealt with in your questions to a large extent with my submissions and the points I wish to make. So having said that, perhaps one aspect to be set out is just a background as to where this is. I have set that out to a large extent in my written submissions, but I need to point out just these aspects, and that is that the original rescission application, of course, dealt with and requested a rescission of the executability aspects. And in that application, the applicants dealt with, very briefly, but dealt with the issue that executability ought not to have been granted, and that at least there should have been a report back date or something of the sort had the court been aware of who was occupying the premises. Having regard to all of those facts that was placed in the rescission application, the matter was eventually settled. And it was settled by informed consent, where both parties were very much represented by counsel. In fact, it was myself and Mr. Cohen who presented the parties at the time, so they were represented by very adequately. To that extent, it's different to the matter in Berea, where the settlement in relation to that PI application occurred, and it wasn't truly informed consent that took place. Having made that informed consent, as Justice Rogers correctly pointed out, the consent is now informed. The judge that deals with the settlement agreement is in a position and is aware of what is stated by this honorable court in Eek versus Parsons, that the court can interfere with the settlement if it is objectionable, but decides not to interfere, having regard to all the facts which are placed before it at that time. And I submit there was no reason to interfere with that order. What is then sought in the rescission application is for that consent order to be rectified. So the variation that's sought is a rectification. And a rectification is a rectification of the legal conclusion of that consent. And that can only be granted in circumstances where the parties were at idem as to what ought to happen, but didn't include it in their order. But none of those facts are placed before the court. So when the rectification is sought, the learned judge correctly finds that there's no case made out for the relief that's sought, and there is no constitutional issue in this. So the sole constitutional issue that was raised was found in favor of the appellants, or of the applicants by the court of quo, which means that they're not in a position to appeal it. If the finding was the opposite way around, perhaps they could have appealed it, and if that finding affected the reasoning of the judgment, but it didn't. So the finding is that Rule 46 capital A is applicable. Having said that, perhaps I should just then raise the aspect which was raised by Justice Rogers in relation to the occupation by the trustees and their children and the effect of that. And I submit that the matter which was relied upon by the court of quo is in fact incorrect, and that the matter of Investec and Fraser, which is a judgment in the Gauteng division, 2020 volume 6, page 211, that's not in my head, so I apologize for that. So it's Investec Property versus Fraser, 2020 volume 6, 211. In that judgment, it essentially reiterates what Justice Rogers indicated and in the manner in which he phrased the questions, that the trustees are not entitled to occupy, and that the trust, having given occupation to those parties, doesn't raise the trust to the party who is resident on the property, which is the second question posed by Rule 46 capital A. So Rule 46 capital A, to my mind, I submit, has two phases. The first is it residential property? And the second is that residential property the primary residence of the judgment debtor? So perhaps just to deal with the aspect, the basis upon which, of course, there was no basis to interfere with the original quota quo, that is the original order that was granted, because that order can only be interfered with, as is stated in Gondwana and Steko, if the appellants in this instance set out facts which was indicative of the fact that their constitutional rights were being infringed by the order as granted. And there's nothing of this nature in this instance. On the contrary, what we have in this instance is a trust which hasn't paid for some almost 5 years. The facts are that there are no other assets to execute against, and the only possible way to get execution is by sale of the property. So there has been judicial oversight. It's not that there was an absence of judicial oversight. That judicial oversight merely didn't decide to grant a sale by reserve. That in essence is my submissions. I don't know if there's any questions which I need to deal with.
It seems not, Mr. Dube. Thank you very much.
Thank you, Justices.
Thank you. Mr. Cohen?
I have nothing in reply, Justice Madlanga.
Thank you very much to both counsel. Judgment is reserved and the court will adjourn.
As the court pleases.
As the court pleases.
Today's proceedings are concluded. The host will now terminate the meeting.